Hi everyone, my name is Nafisa Nazarelli and I'm a Managing Associate Lawyer at Russell Alexander Collaborative Family Lawyers. We post videos about divorce, court cases, parenting time, and other topics related to family law. Please subscribe to our channel and hit the bell icon to stay up to date on family law. In today's video, we'll address the question, can I keep my ex's new partner away from my kids during COVID-19 and indefinitely? Say you and your ex have split and he or she has gone on to form a new romantic relationship with someone else. The relationship may be an established one or it may be a brand new, but either way, your concern, quite understandably, may relate to items such as the amount of time the children spend in the new partner's company, the extent of his or her caregiving and discipline imposed, the overall influence that new partners may have on your children, differences in values or lifestyle that the new partner may expose your children to, and the message that the new partner's presence will convey to your children. For example, that your own role in their lives is about to diminish, or that you are being outright replaced. You may wonder whether you're legally entitled to voice your say or have any influence on the situation, particularly if you are not a fan of the new partner personally. Can you refuse to cooperate with your ex's custody and access entitlement to avoid having the children spend time with a new partner you don't like? Can you refuse to allow your children to have overnight visits if the new partner is also staying over at your ex's home? The short answer to these questions is generally no. You and your ex both have the right to form new relationships, unless there is a court order in place that expressly prohibits your ex from exposing your children to any new romantic partners, which frankly is rare. Then there may be little that you can do. Of course, this presumes that your ex has valid custody or access rights and is exercising them in a reasonable and appropriate manner, with no concerns over the child's health, safety, or well-being. If there is doubt, a court will certainly assess the situation from the vantage point of what is in the children's best interests. But leaving aside any normal human resentment or jealousy of your own, the motives for blocking your children's access to a new partner are likely not based on any legally recognized concerns. In other words, you probably just have to live with it. With that said, the situation might be different if you and your ex have expressly agreed not to expose the children to a new partner or to do it only gradually, and that agreement is breached. It may give rise to disputes between the two of you, which in turn may prompt friction on the bigger issues of custody and access. This was precisely the scenario in a case called Billard and Billard. The parties disagreed on whether the child responded well to the weekly arrangement. However, he did agree that he does better with a structured routine. The parties had discussed and agreed to a slow introduction of new partners and that the child would not be taken overnight to a new partner's home. When the mother learned that the child was spending time at the new girlfriend's home, she raised safety concerns about the presence of a large pit bull dog and a ball python. She also requested the new girlfriend's address, which was not provided. These simmering issues came to a head one night in November of 2013 when the mother removed the child from the home of the father's girlfriend, who was caring for the child while the father was out with friends. That incident significantly eroded the relationship between the parties. Access became difficult as a result. In these kinds of situations, a court may regulate the children's exposure to the new partner and rule on the extent to which they are to be left in that person's care, if any, all as part of a custody access order that binds the parents. Now, what about during the COVID-19 pandemic? The court's position on the issue during COVID-19 has struck a slightly different tone. Courts have shown to find that the best interests of the child rest in following public health protocol, which may result in an alteration of custody in some situations. Our firm has seen and reported on cases where parents want to remove custody access for the other parent if they are not taking COVID-19 seriously. We have also seen courts in the United States go as far as to remove custody rights of a parent who refused to get vaccinated. This decision was later overturned due to public backlash. The courts are going to make their decision based on what they think is in the best interest of the child. This means that if you are attempting to keep your kids away from your ex's new partner, you may only be successful if they have shown to have a high disregard for the seriousness of the pandemic and public health protocols. That's it for today's video. Please give us a thumbs up if you found it helpful. And don't forget to subscribe and click your notifications bell so you don't miss an upload. Thanks for watching.